If I can have your attention, everybody, thank you. I haven't seen you in plenary since last Thursday, and I must say I see quite a change. As we said to you, you would work very hard and have a lot of fun, but I also see that you've relaxed and clearly become good friends, and it's a real pleasure for me to see that kind of integration. It's also a pleasure for me to see that you're sitting, but you're still standing. After such hard work. And now I think you're going to enjoy yourselves thoroughly in the interview that will be done by Prof. Weiler of Chief Justice Sundaresh Menon of the Singapore Supreme Court. The Chief Justice is a good colleague and friend of mine, one of many senior legal people in Singapore who have welcomed me and others into the international practice here. We have a few things in common. The Chief Justice and I both are members of the New York Bar. We both practiced, or in his case, practiced international litigation and arbitration. And the Chief Justice spent some time in my hometown of Boston, Massachusetts. And there it stops. The Chief Justice graduated from NUS, first-class honors, and then got his LLM from Harvard Law School. In 2008, he was appointed senior counsel. In 2010, he became the 6th Attorney General of Singapore, and in 2012, he went on the Court of Appeal and became the Chief Justice of Singapore. He's also president of the Singapore Academy of Law. We just had a dinner last week, and thinking about all that the Chief Justice has done, if I just hear those initials, someone says CJ, and I think innovation and energy. The Chief Justice, of course not single-handedly because he has very strong teams, but I think single-handedly comes up with ideas for innovation in legal practice, legislation, and the courts in Singapore like I have never seen. And it's not just ideas. They are ideas that are implemented and staffed with great talent and followed through. I think areas include technology, artificial intelligence, what's coming our way in the region in practicing law, whether we like it or not. The lesson is to be ready. I think you will hear this in the interview to follow and see the energy that comes with it. The interview today, I understand, although things can take their own ways, will focus on first the rule of law for prosperity in the region, and second, following on the moot exercise which you just did, which was done and pioneered last year by Chief Justice and others. They'll be talking about enforcement of ASEAN agreements in ASEAN national courts. So with that, I will sit down and invite the Chief Justice and Prof. Weiler to come down to the stage.
So welcome.
Thank you. Thank you, Joseph, and thank you, Lucy, for those lovely words. Thank you.
So we're all keen to hear what you have to say about the rule of law and convergence and development, but we're also very curious about you as a person. So I want to start the interview with a few minutes, the life and times of the Chief Justice of Singapore. And maybe we can start with your childhood. I mean, I think your story is a classic story of Singapore as a melting pot. So tell us a little about your family and growing up in Singapore. You saw the whole change to an independent Singapore, etc. So what was it like as a child?
Thank you, Joseph. First of all, let me just say it's a real pleasure for me to be here with you this afternoon. I'm an immense believer in dialogue across borders, and particularly in our region, in ASEAN. And I want to really thank Lucy and Joseph and all the people who've put together this ASEAN Academy and brought all of you together, because I think that these kinds of dialogues are tremendously important and helpful for the work that we're doing. So Joseph has asked me to talk about my childhood, and I'm going to take a bit of a liberty and actually begin the story 10 years before my childhood, before I was born. I was born in 1962, but my parents arrived in Singapore in 1952. And I think it's really important to understand that background, because I think that has shaped my outlook on life, and it has shaped my whole sort of commitment to this importance of the rule of law and many of the things that we're going to talk about in a very real way. My father had fought in the war on the British side of the war in Burma in the 1940s, and he got married soon after the war, and they were living in India. He was working in a tea estate, and life could have been very, very different for me if that had been the way they had continued, if he had continued just to stay there. But at some point after they got married, they decided that they were going to move from India, and they decided that they would move to the east, to Southeast Asia. And actually, it's interesting, you know, you've watched that movie Sliding Doors, and how little things can have such a dramatic impact on your life. My parents were actually on their way to Malaysia, because my father's best friend was working on a rubber estate in Malaysia, and his intended destination was to head there. My father's best friend did extremely well, as it turned out. My father would have been a complete failure if he'd ended up in Malaysia, because his friend was a businessman by nature, and my father was anything but a businessman. So he got off the ship in late 1951, early 1952, and had really next to nothing. My mother did not come with him at that time, because she just had my sister, and she was recuperating from that. So he got off the boat by himself, and as he told the story, he had a suitcase with literally an extra set of clothes and virtually nothing else. And as far as he was concerned, this was meant to be a transit stop. He was on his way to Malaysia. But they happened to have some relatives who were already here. They had migrated here a few years earlier. And those relatives told him that he was not going to go any further. He was going to stay in Singapore, because they thought that the thing he should do was to work for the government. And he was open enough to this idea. And so in 1952, he joined the government as a clerk. And that's how life changed for me. Now, they came to Singapore because they felt that they wanted a better future for their children, for the children that they were going to have. And I have to tell you, my entire outlook to the law and to the importance of the rule of law, the importance of equal opportunity, is immensely shaped by this picture of my father in 1952 standing by the side of the ship, lost and lonely, and trying to see whether he could possibly have imagined that 60 years later, his son, who had yet to be born, would be the Chief Justice of this place. That has immensely shaped my outlook on many of the things that we're going to talk about later today. But that's how it happened. So he came in 1952. By the time I was born 10 years later, they were modestly comfortable, in the sense that a few months before I was born, they actually bought their first house. But for the 10 years that they were here, before I was born, my parents, my siblings, my sister and my brother, who are nearly 8 and 10 years older than me, 4 of them shared a single room with another family. 8 of them shared a single room. And those were extremely hard times, which I didn't see, because I was still a concept at that time. So I didn't see that part. But my father went through those years. He held 3 jobs, tried to train himself to get himself into a better position, better qualified. And all of these things are not just nostalgic memories, but they're relevant because it takes a certain framework to allow someone in his position with nothing really, no connections, no great position to be able to progress in society. And for his children to thrive in society, it takes a certain set of conditions for that to happen, where you're not dependent on how well connected you are, you're not dependent on whose favor you enjoy, but you're primarily dependent on a commitment to work hard and do the best that you can, because everybody has a fair shot and everybody has an equal opportunity. By the time I was born, as I said, they were, reasonably comfortable. I grew up in a little house. They had a little car. And I didn't know the worst of those issues or worst of that period that they went through. But Singapore was still a very different place. And I can remember walking with my mother to the market and her being robbed, literally robbed, by someone who came with a knife and plucked a gold chain off her neck. I remember this as a little boy. I was 3 or 4 years old. I still have that image in my mind. It was something that is not really imaginable today. You don't think of Singapore that way, but this was it was not unusual back in the 60s when this happened. I also, however, remember that within 3 days, and I kid you not, within 3 days, the policeman came to our house, and we had a little marble table outside in the little garden that we had. And I remember sitting there with my mum, and the policeman had a fistful of gold chains. He must have had 30 gold chains. And he put them on the table and he said, "Is yours there?" And I remember my mum found the one that was hers, and they knew it was hers because they knew where the others came from. And that tells you something about law enforcement, police authorities, and a commitment to try and make sure that rights and expectations were fulfilled and were honored and were respected, and there was a real commitment to try and do that. To come back to my little narrative, 1969, I was 7 years old, and I left Singapore with my parents because my father by then had been transferred to the Foreign Service. And our first posting was to Cairo, and I spent 3.5 years in Cairo. I picked up fluent Arabic. So fluent was my Arabic that as an 8 or 9-year-old, I'd go into the embassy with my father on a Saturday and man the phones for him because I could speak Arabic. I spent 3.5 years there, enjoyed it tremendously, spent a couple of years in Indonesia, spent a couple of years in New Zealand, and then finally came back to Singapore where I did my A-levels and then my university. When I was growing up in Cairo and until the age of about 12, my ambition was to become a pilot. That was what I wanted to be. And I suppose at that time it was a really glamorous thing. If you've seen the movie Set a Thief with Leonardo DiCaprio, it's set at a time where pilots and air hostesses were amongst the most glamorous people in the world. And I guess that kind of influenced my thinking. But in 1972, 73, that dream was crushed because it turned out that I have severe astigmatism and I couldn't live without glasses. And I'm surprised it took that long, but it did take that long for them to figure it out. And so that went away, and I knew from then that I wanted to be a lawyer. I didn't know why. I didn't have a very clear understanding of any of the key parts of the rule of law, any of those things, but I knew I wanted to be a lawyer. And what I thought about lawyers was that these were people who fought for others, who fought to make things right for others. That was the extent of what I understood about the profession, and it seemed to me to be immensely inspiring. And so I decided that that's what I wanted to do. And I knew I wanted to be a litigator. I knew I wanted to be an arguing lawyer, not a transactional lawyer. So that kind of set my direction. And after I finished my national service, I went to the National University of Singapore, studied law for 4 years, graduated, and went into practice. And if I can give you a very quick thumbnail sketch, I spent I guess from 1986 until about 2003, about 16, 17 years in 2 or 3 Singapore law firms, practicing primarily as a litigator. And then in 2003, I joined Jones Day, the international law firm, where I was head of disputes for Asia. And I held that position for 3 years until I moved to the Supreme Court, initially as a judicial commissioner for 1 year. And after I finished that stint on the bench, I felt I was still a bit young and I think still buzzing with quite a lot of things I wanted to do. And so I decided I wanted to go back to practice. I went back to practice as senior partner and then managing partner of Raja & Tan until 2010, when I accepted appointment as the Attorney General and then as subsequently as Chief Justice. So that's been in a very, very quick thumbnail sketch, Joseph. That's been my personal story, if you like.
Were there any figures in the world of law that served as role models for you? I want to be like.
Not when I was growing up. I mean, it's actually true. I read To Kill a Mockingbird, and that left quite an impression.
Atticus Finch.
Atticus Finch, left quite an impression, and what a classic story that is, what a timeless story that is, just about lawyering for the sake of doing right, and just what a wonderful feeling that is. But in practice, when I finally made it to, along the way, I should say a couple of things. I mean, as a young person growing up in Singapore, Lee Kuan Yew was larger than life. And everybody knew he was a lawyer, and he was quite a fearsome lawyer, quite an outstanding lawyer before he became a politician. Certainly in law school, I remember being deeply affected by David Marshall, who was another gigantic figure in the legal profession, who had been perhaps the leader of the bar in Singapore for decades. And then subsequently, he was actually our first chief minister. Before Mr. Lee Kuan Yew became prime minister, he was the chief minister. And he was a real colossal figure in legal practice and a barrister. And he loved the law. And I remember him giving a talk in the university which I attended, when he spoke disparagingly about the threat to this idea that law is a profession. And he said, it is not a business, it is a calling, it is a profession. He said, don't ever let gold dust into your veins. I remember those words. And that certainly was something that I found very inspiring. When I came into practice, I think I said in another context, my one regret looking back over a wonderful 25 years of practice, my one regret was that I didn't do more criminal justice work on a pro bono basis. And the main reason I didn't was, whilst I was in the bar, most of my work was in commercial disputes. I would say 95, 98% of my work was commercial disputes. And I felt I didn't know enough criminal law to take these cases on. And now, as a judge who writes extensively in criminal law and hears criminal law cases, I wish I'd done it. Because I think that a good heart and a good mind is ample to make a real difference for these people. And that's one regret that I have.
But it seems that that problem still remains, because from my experience here, I've never heard any of my brightest students saying, I want to be a criminal lawyer. They all want to do commercial law.
Yeah, it is.
And David Marshall was a criminal lawyer.
David Marshall, you're right, was a criminal lawyer. He was first and foremost a criminal lawyer. In fact, I think as much as I say I was 95% a commercial lawyer, he was probably 95% a criminal lawyer. I think it's true that our very best students tend to end up today in private practice, in commercial practice. I think that's driven by a number of different things. But I think the one big difference is there's much more of an awareness of pro bono work. There's much more willingness, especially among the young lawyers, which fills me with so much of hope. There's much more willingness among the young lawyers to take on criminal cases on a pro bono basis.
Maybe they're less criminals today. Just teasing.
Yeah. But we do have a number of avenues for that side of lawyering to still be nurtured.
One last question before we come to ASEAN. So as a child, you had this international experience in Cairo and New Zealand and Indonesia. But as an adult, after you graduated law school, etc., did you also have international experience?
My wife and I love traveling, and we travel extensively. So we do travel extensively. But the answer to your question is, apart from a year and a bit when I was in Boston, I haven't lived outside Singapore in the last 35 years. But my practice was extraordinarily international. During my practice days from 1995 till about 2010, when I left practice finally, I would say nearly half my work was outside Singapore.
I see. And one very last question. You know, seeing from the outside, Singapore is one of the most successful multicultural societies. Did you ever experience any kind of discrimination on account of being Indian in any phase of your life?
No, but that's not a complete answer. I've never encountered or experienced discrimination, but I would say that there have been times where, well, let me rephrase that. I have never encountered any disadvantage on account of my race. And the fact that I hold this office is testament to that fact. I've never been held back in my career. I've never been held back in anything that I've done as a lawyer, as a professional, on account of my race. And I genuinely, truly believe that our policies and our government and our commitment is entirely race blind. I truly, genuinely believe that. But it's not a complete answer, only because it would be artificial to imagine that we are utopia. It is artificial to imagine that at the level where you're sitting in a park or sitting in a shopping center or in an MRT train, it'll be artificial to imagine that everybody looks at you and doesn't see what race you are, or doesn't sometimes think, that you're a different color or a different race. I think that it would be artificial to imagine that that is the case. But it has never, ever got in my way, and it has never, ever bothered me. I've never felt vulnerable. I've never felt disadvantaged on account of my race at all.
It speaks very well about the society. So we've been spending this week in different ways with different modules, different teachers, different exercises, different practicums dealing with ASEAN. But it is the Academy of ASEAN Law, and I suppose looming in the background, I don't believe without that, was the Charter. And one of the things the Charter was meant to do was to push ASEAN, which was very successful politically, to more of a rule-based system. And it would be interesting for us to hear your take. What do you understand by a rule-based system? And why was that such a centerpiece for the Charter, which at least symbolically towers over all other ASEAN instruments?
I think I want to begin with, I want to break my answer up into at a theoretical level and then at the level of reality and practice. One of my genuine passions is the rule of law, and I think in the 7 years or so that I've been Chief Justice, I must have given well over 100 speeches and lectures, and you will be surprised how many of them revolve around aspects of the rule of law. And that's ultimately what the rules-based system is directed at. This idea of the rule of law being a reality and being an enabling feature of the development and progress of ASEAN. So why is it that I think that the rule of law is so fundamental? I think that the rule of law should be seen in all nations as being in the enlightened self-interest of governments and states. And I see the rule of law as a powerful, powerful enabler and framework for development in nations. if you talk about a genuine commitment to alleviating poverty, alleviating hardship, I think that at the foundation of that is a sincere and genuine commitment to the rule of law. And I say that with my personal experience. I told you the story of my personal history, if you like, over the last 60 years or so. And I don't think that would have been possible if not for the fact that Singapore itself became deeply devoted to the rule of law. And that in itself was driven by necessity. When Singapore became independent in 1965, we really were, in a sense, high and dry because it wasn't something we sought, it wasn't something we expected, it wasn't even something that was the goal of the freedom fighters, because freedom for Singapore was always seen in the context of being a part of a much larger union with Malaysia, which was a big, rich, wealthy, which is a big, rich, wealthy country. And if you take Singapore minus Malaysia, without Malaysia, you're left with a tiny space with no resources and really no natural reason to expect that it would thrive and succeed. And if you go back to 1965, when we became independent, this was at the height of decolonization and self-determination. And newly independent countries around the world were all intuitively suspicious of foreign investment. The idea was, do not welcome foreign investment, do not encourage foreign investment, because that will simply lead to a new form of colonialism. So those were the circumstances in which Singapore became independent. And Mr. Lee Kuan Yew and the founding government of Singapore realized that cut in the way they were, without the hinterland, without the ballast of a substantial nation, in order to survive, it was absolutely essential to be able to attract significant amounts of foreign investment. And that was the necessity that drove this absolute commitment to the rule of law. Over the years, by this insistence on the rule of law, by this determination to eradicate corruption as much as you possibly can, by having governance, proper standards, Singapore was able to attract investment. And that was key to our development story. 10 years ago, our law minister made a speech in which he talked about there being 10 years ago, nearly $600 billion worth of foreign investment in Singapore. And he said that wouldn't happen if people didn't trust the legal system, if they didn't trust the fact that their investments were protected by the law. So it is that adherence to the rule of law that has driven the Singapore story in terms of its progression. And I believe that if we take that story to a wider sphere, that is the reason why I carry this message to my counterparts, to government leaders throughout the region, and tell them the rule of law is fundamental. Now, if I may, Joseph, let me tell you a story. So amongst the nations I visited is one nation in Asia. And when I was there, the Minister for Justice invited me to visit his ministry and to have a dialogue. And he asked me this question. I'm going to narrate the conversation to you because it's quite revealing. He said, your title is Chief of Justice. Well, it was slightly wrong, but never mind. He said, what does that mean? He said, do you have the last word on all disputes? And I said, not me, but my court. My court has the last word on all disputes. And he said, but surely that can't be right if you have the government involved in a dispute before you. I said, no, it is absolutely right. We have the last word. If the government is involved in a dispute with a citizen, the courts have the last word. And he looked at me and said, no, I don't get that. He said, it can't be that if the prime minister is before you in a case, you are going to be able to tell him what his position is and whether he's right or wrong. And I said, that is absolutely the position, because that is what the rule of law means. And he looked at me incredulous. And he said, why would any government do this and give this kind of power to judges? And I said to him, I narrated to him our development story. I said, that's why you do it. And he said, but can't judges make mistakes? I said, of course they can make mistakes. And who says politicians can't make mistakes? Everybody can make mistakes, but that's not the point. You need an impartial adjudicator to resolve the disputes fairly, neutrally, and independently. And it starts with governments accepting that the rule of law is fundamental. And when that happens, you have the foundation from which people can progress, investments can come in, and the nation as a whole can progress. And he didn't accept it, he didn't embrace it, but at least I think I planted a seed. But I believe in that very, very strongly, and I think the transition to a rules-based framework for ASEAN was part of that commitment to try and ensure that things don't remain at the level of dialogue and words, but in some way percolate down to affect people on the ground in a good and positive way. I think that's the significance of it.
So let's change a little bit the order of the interview. I share your view that I think we share the same view, that it's difficult to speak about the rule of law if judges don't have the last word, if we lead it to the other political branches. Because it's exactly what you were saying. The rule of law is the ability to tell a government, to those in power, even if it's a pauper in front of you, that the government wrong and the pauper is right. So the last word has to remain with the courts. And any country which we can credibly say believes in the rule of law, we will find exactly that the last word remains with the courts and not with the executive branch, and in some cases not even the legislator, because there's judicial review for constitutionality. But if I look at ASEAN as a reality, it's not a reality where when it comes to ASEAN commitments, the last word is in the hands of courts.
So I said that I was going to divide my answer into the theory and the practice. And I think that this is a journey. That's what I think. This is a journey. I think that it is a big step to move from having ASEAN exist at a level where a lot of the action takes place at the level of the summits and the political discussions to one where it translates into meaningful rights and realizable rights. I think that is a journey. And I think that that's a journey that has to take place at a pace that is sustainable and realistic. ASEAN is a huge entity with immense potential. We have upwards of 600 million people. And within this geography and within that scope of area and population, you have tremendous diversity in any number of ways. The levels of development are different. The levels of income are different. You have places like Singapore, which is a city, a tiny city where everybody lives in the city. And you have countries like Indonesia, which are vast countries with people living thousands of miles from the capital or even hundreds of miles from a city. You have such diversity within ASEAN that it would be, in my respectful view, unrealistic and even unwise to attempt to force the pace for this journey from the theoretical adoption of a rules-based system to a practical adoption immediately. If you look at massive transformation, constitutional transformations that have taken place around the world in our lifetimes, you look, for example, at what happened with the Soviet Union. The rapidity of that pace of change that happened probably led to a real shock to the system that undid that union as a whole. And I think that in the context of ASEAN, this needs to be given time to make it happen and to make it successful. What I find particularly interesting is the development and emergence of new ideas that have been floated in recent years with lawyers, with ASEAN law, for example, with the Secretariat, which could make significant steps in this direction. I'm happy to talk about that if you like.
Let's get to it towards as we progress in the interview, but let's keep that question in our mind, because it's one of the paradoxes of ASEAN that at one level it's incredibly successful politically in resolving political disputes. It's a zone which has lived pacifically for practically its entire existence, and in no small measure thanks to ASEAN as well, not just to the goodwill and sensibility of the politicians. And at the same time, we still have, the dream of a rule-based system is still a promised land that has to be arrived at, as you say, at the right pace. But if we leave that aside for a minute and come back to it later, I know that one of the themes that really interests you is convergence. And maybe you can explain to us what you mean when you talk about convergence.
Thank you, Joseph. I do really care a lot about convergence in legal systems and in particular areas of law. And let me explain this. We live in a world today that is so interconnected. It is unbelievably interconnected. Today, in every way, trade, movement, services, they are all interconnected. I can't remember the precise number, but somebody once said that an iPhone consists of components made in about 17 different countries, for example. So in that kind of a context, if you acknowledge the reality that the commercial context of the world today and even the social context of the world today is one which is incredibly interconnected, then I think it is not ideal when you have very serious divergences in legal regimes that are applicable as you cross borders. Now, I accept that each country has to have its own political system. That's fine. I accept even that each country has to have ultimately its own levers through the law, which it uses to implement various social policies and social goals that are important to that country. I accept. But if we just focus for a minute on one area, commercial law, there is actually very little reason for there to be substantial deviations and divergence in commercial legal systems. And it is especially the case because of the fact that commercial practice is organized on a cross-border basis today. Most regional companies run their operations on a regional basis. Their headquarters serve a region. Their legal counsels serve a region. And it's just unsatisfactory to me that each time they go to a different region, they're encountering different legal systems, different legal requirements, different legal regulations. Now, again, this is a journey. It's not going to happen overnight. But imagine if we lived in a world where on key points you had relative stability in legal regimes as you moved across borders. This is a particular problem in recent years because if you go back to colonial times, there was a large degree of convergence because of the empires. The common law world largely had a British-based legal system. Then you had a whole lot of countries whose legal systems were based on the civil law systems, the Dutch systems, the French codes, and so on and so forth. But when you suddenly become independent and movements are happening across these borders, the divergence becomes an impediment to promoting trade and development. And that is the reason why I think in the field of commercial law, it is very desirable to have greater convergence. Now, how do we do this? In broad terms, you can think of commercial convergence in terms of top-down mechanisms. I think, for example, of arbitration, an area Lucy spoke of that all three of us have extensive experience and involvement with. Arbitration today is one of the only truly transnational legal frameworks that exists for the resolution of commercial disputes. And it has been able to achieve that because through top-down efforts like the New York Convention, the UNCITRAL model law, you are able to get a very substantial degree of common ground and common expectations on what's going to happen when you move across borders. You more or less know what you're going to expect. I don't say it's identical, but you more or less know what you're going to get when you cross borders. And that has really helped in promoting arbitration as that kind of a cross-border transnational system for the resolution of disputes. You could find other examples. Think of the Convention on the International Sale of Goods, another top-down instrument that tries to provide a high degree of predictability and stability in the legal context when you cross borders. The problem with these top-down measures is that entering a treaty is not always straightforward. And governments have political priorities. Those political priorities may not cause them to feel that these particular issues are relevant. And to a large extent, there aren't enough treaties anyway to go around and address all the complexity of issues that need to be dealt with. So one of the efforts that I have been involved in has been the establishment of the Asian Business Law Institute, which is something that we set up about 4 years ago. And I set it up under the auspices of the Singapore Academy of Law. And the Asian Business Law Institute tries to bring together scholars from across Asia. And so far, we have been doing our work typically in 2 steps. Take an area. So the first project that we did was on the enforcement of money judgments across borders. And if you started with that, you'd be shocked and you'd think, oh my goodness, there's so many differences on what I do with a money judgment and whether I can enforce it across borders in Asia. We started with that. The first phase is what I call a mapping exercise. We covered 15 jurisdictions across Asia, and we had leading scholars from these jurisdictions come together and present a map or a description, just a description of what is the law on the enforcement of money judgments across borders in their country. We compiled this into a publication, which is now published already. And when we had this, the first thing that immediately jumps up is there's an amazing degree of common ground across borders. There are differences, but there's actually quite a lot of common ground across borders. And now they're doing the second phase of the exercise, which is to develop a statement of principles that tries to identify the common areas and also tries to identify the areas where there are differences with proper references so that someone can pick it up, one source, and see where you can find a common principle and know where you don't have a common principle. And I think this will be tremendously helpful to business. I think it'll be tremendously helpful to companies. And I think this will drive common ground because you will look at what everybody else is doing, and that consciousness alone, I think, will tend to drift you towards the middle. And it's an idea that we borrowed from the practice in the US of the restatements. That's how the US restatements have worked to try and drift legal developments across the states into a common direction. The Business Law Institute has had 2 projects which are well in advance: the enforcement of money judgments and rules on the movement of data across borders. And the third and fourth projects, which are underway, extremely interesting projects. The third one, which I think is a very, very interesting and important issue, is the principles for restructuring in Asia, corporate restructuring and reorganization in Asia. We've got a fantastic team of experts, judges, and scholars putting together a similar exercise of a mapping followed by a statement of principles. And the fourth one, which is a little further back, is on looking at principles of contracting in Asia. And I think that these would make a viable, useful contribution to promoting trade and development.
So, and that is very consistent with what you were saying before, that this road, this promised land of a rule-based system, etc., is probably more effectively achieved with a bottom-up rather than a top-down approach, which means that a key role will not be played by the ministers of justice meeting in Jakarta or in Manila, etc., but by the legal community of lawyers that are practicing, etc., and even before that, by our different systems of legal education. So give us, I mean, it's a big topic, but give us just the flavor of your thoughts about legal education and the role of lawyers in this kind of ASEAN enterprise.
So the first thing I would just say on that point, before I turn to education and the role of lawyers, the first point I would make on this point is that I think that they are all key players. It's not that the ministers are not important, but I think that in order to move along this journey, we can't expect it to happen purely at the legislative level. We can't expect it to happen purely at the legislative level. But the ministers are doing important things and vital things to promote that framework. But it then leaves a lot of space for lawyers on the ground to pick it up and start moving the pieces along. And I will come back to that a little bit later. Legal education. I think one of my biggest commitments at the moment, outside of my judicial work, one of the biggest things that I'm looking at the moment is actually legal education. And it started with a lecture that I delivered in the US last year, the James White Lecture on Legal Education, where I suggested that we were at a point in time where legal education was in need of a fundamental overhaul. Admittedly, I'm speaking primarily from the perspective of the common law world, and I don't purport to know a great deal about how law is taught and practiced in the civil law world. I have some familiarity, but I'm speaking primarily from the common law world. And I felt that in the common law world, the whole approach to legal education was very much backward-looking, in large part because of our system of precedent and judicial precedents and the common law. We tended to be very much backward-looking. And this, I thought, was not fit for purpose in an era of unprecedented change and change that is happening at an unprecedented pace. So I think that we really need to re-examine how we go about legal education, not only in terms of how we teach it, but also in terms of what we want our law students to have. And the more I started getting into it, the more difficult this problem began. And at the opening of this legal year, I said, I don't have a solution because this is such a large problem. And what I said I would do was, I said I would spend this whole year meeting people and listening to people and understanding how they saw the issue, so that I could, with the benefit of all of those inputs, try and figure out what we might do. And that actually has been taking up a lot of my time this year. I've met more than 100 different people in different settings, and I have several more meetings lined up to think of solutions, including meetings with the deans, with the law schools, trying to understand what the issues are. My view on legal education, this is dealing with the technical aspects of it, my view on legal education looking ahead is we're going to need much more emphasis on multidisciplinary training, much more emphasis on soft skills, not purely focusing on drilling down the black letter law. There are certain core features of law that you have to teach because you have to explain and get across the legal method of reasoning. But I think we have to fundamentally rethink the way we approach it. I also think that there needs to be much more dialogue and collaboration between the practice and law schools. practitioners and law schools. I think there needs to be much more. I think it'll be interesting, for example, to think in terms of more mid-career professionals coming in for JD programs or shortened law programs so that they have another background and they come in and convert to lawyers through accelerated programs. I think those sorts of things will be very useful. I think lawyers of the future must have familiarity with technology. They must have familiarity with technology. They may not all have to be coders, but they need to be able to understand what technology can bring to the law so that they are alive and can think about how they can reshape their practice in order to use technology in this way. I think that's an essential requirement. And then the final point in Joe's question, I think that the other big threat that we face in legal education is overlooking the danger that we cease to think of ourselves as a profession. I think that's a really, really dangerous position to be in. Law has historically been seen as a profession, and what do I mean by profession? I call it a group of people pursuing a learned art in a spirit of public service. That was the famous definition that Dean Roscoe Pound gave. And it's a definition that I really like because it emphasizes several things. But the most important thing it emphasizes is that we do what we do in a spirit of public service. And I have a real concern that as the practice of law industrializes with all kinds of different models of legal structures, there are the emergence of alternative legal structures with different types of players entering the field. There's a real danger that we lose that defining characteristic of being a legal professional, that commitment, that devotion to doing our work in a spirit of public service. And I think if we lose that, then society will be much poorer for it.
So I want to pick up one point that is maybe a horse I flog too often, but I still would like to hear your views, and I think our participants here would like to find. So I myself studied law in the United Kingdom, and believe it or not, I've been 40 years, I've taught in 80 different universities around the world. And there's one fault line which to me is very significant. So you talk about the need to be familiar with technology and economics, and you use the word interdisciplinary. And a year ago we heard your successor as Attorney General also speaking about the need for lawyers to have a much broader view of the world in which they work. They can't just be closeted in their office. And the fault line is the following. I think, for example, my American students, I taught at Michigan, at Harvard, I teach at NYU now, they are not more brilliant than my Singaporean students. I think a Singaporean student coming to NYU, they usually end up at the top of the class. They're very, very able. The difference is the following, that all my American students have 4 years of college behind them. They are sitting people with degrees in political science, in economics, in chemistry, in engineering, and they are older. They are not 17-year-olds, they are 22 or 23-year-olds when they come to the law school. And I've seen the same thing teaching at Melbourne, which shifted to that system. We're only going to take graduates because we think that background is important for them to be good lawyers, and because we want to be teaching mature students, not people right out of law school. Isn't it? There's a lot in the United States legal system and legal education that we can do without. But I think that approach, that the training of a lawyer should not be straight out of law school, out of high school, but give them time to get a broader education, to familiarize themselves, and also to decide, I really want this vocation, and not just because my parents told me that's what you should do. Is that part of your agenda?
it is part of my view, Joseph. I think it's more correct to say it's part of my view. I wouldn't say it's part of my agenda simply because I don't have the political role to have an agenda in this field. But I have a strong view, and I entirely agree with what Joseph has said. I think that it is unrealistic to expect. I was lucky because at the age of 12, I kind of knew that that's what I wanted to do. And I couldn't imagine my life doing anything else. To be honest, I couldn't imagine it. But not everybody is that blessed or that fortunate. And I think it's unrealistic to expect many 17 or 18-year-olds to know at that stage, this is what I want to do. And most of them, I see this. I interview many young lawyers for different positions in the legal service each year. And when I ask them the question, why did you end up in law school? A surprising number tell you exactly what Joseph has said. Well, I did very well in law school. My parents said this is what I should do. And I'm sorry, that's not good enough, because your parents aren't the ones who are going to be slogging the hours and, just working really, really hard. And that's something that a successful, satisfying career is going to need. And you need to feel that desire, and you need to feel that calling that this is what I want to do. So at a personal level, I really do feel that would be a hugely beneficial step to take, to get to a stage where people make this decision later in life because they know by then what it is that they want to do and why they're doing law, and not depending on the default choice that this is what my parents want me to do. The overwhelming majority of students that I interview, or young lawyers that I interview, overwhelming majority, 70-80%, will say that I'm doing this because somebody else told me this was the thing to do, and not because they say this is what I wanted to do and this is why I wanted to do it. And if we move there, it's a big move. If we move there, I believe we would significantly address one of the problems we have encountered. Perhaps it's the same in other jurisdictions, the problem of attrition. Because too many people come into the law. It is, in some respects today, seen as the new liberal arts degree. Many people say, well, I do law, it's a good discipline, it doesn't cost me anything, it's giving me a professional background, and if I don't like it after a few years, I can go off and do something else. Yes, that's all true, but law school positions or places are a limited resource. And we need to make sure that we are training enough lawyers who are going to stay the course and remain in the game for 30, 40 years. And that, I think, is a real challenge.
And it's also unrealistic to say you have to be familiarized with technology or with economics, etc. Because once you're out of law school and in the grind of the law firm, when are you going to do it? At 12 o'clock at night when you've come back from the law firm? It's sort of... So there really are advantages and worth thinking. I should say that when I told my father I was going to study law, his remark was, the world would be a better place if you became a plumber. I'm glad I didn't listen to him. Let's come back. We talked about legal education, but now let's imagine whatever the system, the student is out, he or she qualify as a lawyer. What role in those things you were talking about, rule of law, convergence, with the ASEAN agenda a little bit in the background?
I want to come to this by first of all talking about a couple of things that I'm doing now in my capacity as president of the ASEAN Law Association. The ASEAN Law Association is an association of lawyers. It's actually the Pan-ASEAN Association for Lawyers. And we bring together judges, prosecutors, government lawyers, practitioners. It's been in existence for nearly 40 years. My own feeling is I think it has come into its moment because of the confluence of a number of forces. The points Joseph mentioned about the charter, the desire to have a rules-based system, I think all of that, the points I've talked about in terms of interconnectedness, the fact that we are increasingly looking towards a common market, looking towards a blueprint of a unified or a better connected ASEAN. All of those things, I think, have made this the moment for the ASEAN Law Association. Let me explain that by reference to a couple of examples. So the ASEAN Law Association has traditionally had limited visibility. It has had limited visibility because it was seen, it was one of a number of ASEAN organs. And it was seen by the ministers' groups, for example, the law ministers meeting, or the senior law officials meeting. They saw the ASEAN lawyers meeting and they thought, you're private lawyers, what have you got that's going to be useful to me? Why are you telling me any of these things? There's nothing you can do that can really bind or inform the decisions that are made at a higher level and so on and so forth. All that's true, but I think that the role, the future for the ASEAN Law Association and the ability of lawyers to get involved comes in another way completely. And to this end, we started by having discussions with the ASEAN Secretariat. And I have to say, at the last ASEAN Law Conference that we had last year, the Secretary General was unable to make it. His deputy came and delivered a speech in which we were invited to work with the Secretariat as a body to try and come up with ways in which we could help the Secretariat, ASEAN Secretariat, do its work. And let me give you a couple of examples of the sorts of things that are being thought about at the moment. And this comes back to the point we talked about, Joseph, about it being a process that involves players at many levels. So the ministers, the heads of government, they pass instruments, ASEAN instruments, they pass documents that set out principles on a number of things. And at the theory level, once the instrument is passed, you can say a box is ticked. But at the practical level, it's actually important to try and see how that instrument, which has been signed, hands have been shaken, photos have been taken, how does that condescend to the level of the business person on the ground in order to help that person avoid paying unnecessary duties or tariffs? How does it translate to helping that person establish a cross-border business in another ASEAN jurisdiction? In other words, how do we try to improve the implementation of these instruments? And this is an area that we're now in serious discussions with the Secretariat to see how the ASEAN Law Association, which has at its disposal even now hundreds of lawyers in our membership, how we can use those lawyers to play a role in two ways. First of all, diagnostic, preparing country reports. Preparing country reports to look at the extent to which each country is actually able to implement key instruments. And then if a particular country is not able to do it to the extent you'd like it to, understanding what the problems are, understanding what the obstacles are. And then, number three, once you've got to the stage where you understand what the obstacles are, working with the local authorities to train, to bring awareness, and to help implement these instruments. Now, if we can actually achieve that, I think that would be a huge, huge step forward in this journey towards translating the theory of a rules-based ASEAN to a practical level, a very, very practical level.
So, I am old-fashioned. I'm old and old-fashioned. And I still maintain no courts, no rule of law.
Yeah.
So I, apart from helping CND10 to organize the whole academy, I took upon myself to teach the unit on compliance, disputes. And I think I surprised some of the people sitting here when I said you would expect us to spend 4 hours analyzing the dispute settlement protocol. And what I did, I said to them, just read it and forget it, because you will never ever encounter it in your legal practice. And then I said, there is a serious problem of non-compliance, not of dispute settlement. It's a Pacific organization. And empirically examined, most of the non-compliance is at the administrative level.
Yep.
Government officials, not ministers, not parliaments, not how they collect the duties, what forms to fill in, etc. And there I said, why not take a different approach and yes, use no constitutional amendment, use the established principles which exist in all our countries for judicial review of administrative action, and claim that an administrative decision without compelling reasons which brings the country into violation of ASEAN obligation is unreasonable and can be judicially reviewed. I think everybody found it interesting, but most people sitting here were very skeptical. And after I finished, a lot of people came up to me and said, that was very interesting, but unrealistic. In our country, this could never work. Including Singaporeans. You know, we have a dualist system. So you are familiar, we used as a material to drive home this point, the exact moot problem that you judged last year. So you're familiar with the issues, etc. So I'm going to ask you directly, unrealistic?
No. So I want to explain that because this was, in my view, this was one of the highlights of the ASEAN Law Conference, the last ASEAN Law Conference. It started with an idea. It started with Joseph and I having this discussion in New York over breakfast. We talked about this. It started from there, and it became a reality. And I honestly tell you, it was one of the highlights of the conference. We had 3 judges judging the panel. Myself, the Chief Justice of the Philippines, and a judge from Thailand. So you had 1 common lawyer, 1 civil lawyer, and 1 hybrid system, Philippines. You had 3 different lawyers, 3 different legal systems judging an identical problem. So the problem was exactly as Joseph described. There was an instrument that said that there should be no duties.
Very familiar. We did it.
So you did it. And when the arguments were presented, all 3 of us came to the same conclusion with almost the same reasoning. And that reasoning was simply a matter of looking at local law obligations and interpreting those local law obligations in a way that was consistent with the intent and purpose of the instrument, rather than ignoring and violating that instrument. All 3 of us. And we were not trying to reach that conclusion. I went to the mood fully expecting that maybe one or even the other 2 might take a different view to me. But when we sat down and analyzed it with just these 2 principles in mind, what does the instrument set out to achieve? Can we reasonably interpret the domestic law obligation in a way that would be consistent with and advance that intent? If we just applied those 2 principles, we all came to the same conclusion. And all of our legal systems recognize those principles. In Singapore, we are a dualist system. That means that things that happen at the international law do not become automatically a part of our domestic law. But we do have a principle that you interpret your domestic laws as far as reasonably possible in a way that is consistent with your international obligations, because courts really don't have a reason to go through their work assuming that governments intend to breach their international obligations. That's not a natural assumption for courts to make. In fact, the far more natural assumption you want to make is that governments will adhere to their international obligations, and if they've passed some legislation, it's not a big leap to make the assumption or apply an interpretation that advances that. The problem, I think, is that this way of thinking has not been something that our law students and young lawyers are sensitized to. And until that moot, people were thinking this was going to be a joke. By the end of the moot, there were two reactions in the room. One was, wow, we didn't think this could happen. The other was, don't be silly, a court can't force the government to change its laws. And my response was, you're both right. It is wow. And it is true that a court can't go and say to a government, you have to pass some legislation. But that's not the issue. We're not asking the government to pass any legislation. We're simply looking at existing legislation and giving it an interpretation that is reasonably possible and advances and is consistent with it. So I think it is possible, and I think part of our role in ALA, that's the ASEAN Law Association, part of our role in the Law Association, part of our role in legal education is sensitizing students to this way of thinking, which I think will be very important.
And you know, the Irish Constitution, from the day of its birth, had provisions for judicial review of legislation. So this is not the ASEAN situation. It took an entire generation, 21 years before the first lawyer brought a case, because you don't challenge legislation before a court, even though the Constitution said so. So it needs somebody to jump in first, and then it will spread. The Chief Justice has very kindly agreed that he will hand out the certificates. But we have now 20 minutes where I would like to give you the possibility to ask questions of the Chief Justice. So the floor is open, and you need somebody to jump in first. So there we have already your first questioner.
Thank you, Chief Justice, for sharing your life story. Certainly it's very inspiring. I have a question about legal education and technology, which you already touched on. But I have some comments about our ASEAN journey toward becoming a more rules-based organization. I used to serve in the ASEAN Secretariat, and I might be guilty of paying too little attention to ALA when they came for assistance from the ASEAN Secretariat. I know that there is also an ASEAN Law Student Association. I think that should also be involved in promoting legal education. My comment about the journey toward becoming more rules-based is that after the entry into force of the ASEAN Charter on the 15th of December 2008, I noticed that more and more ASEAN delegations, they would bring with them a copy of this ASEAN Charter to ASEAN meeting. And they can always cite relevant articles to back up their argument. So I believe this is a sign, a good sign of ASEAN becoming more rules-based. Now my question, I already asked Professor Weiler, and he gave us his answer already. I asked him whether he foresees the use of robots with artificial intelligence to teach law in law school, and he said not in his lifetime. But he also told us that it already happened in law office as far as data collection and record keeping is concerned. So my question to you, sir, do you foresee the use of robots with artificial intelligence in arguing a case before your court in the near future? Because certainly the robot have no language barrier, have no fatigue, can have instant recollection of all cases and judgment, but then they don't have any human sentiment. Whether or not justice will remain a human issue requiring human intelligence in the future?
Thank you. It's a fascinating question, and it's one I'm deeply interested in. Maybe before I turn to your question on AI, let me just pick up one point. You talked about the ASEAN Law Students Association, and I wanted to mention to this audience, and I think Joseph is aware of this, that part of what we're also trying to do in the ASEAN Law Association is actually to institutionalize this moot that we did last year as part of a trial. We want to institutionalize it as a competition amongst the universities in ASEAN. and get the ASEAN law students to participate in that competition so actually they work with the issues and become a little more sensitive. And that's one way in which we hope to raise the sensitivity. So I just wanted to mention that to you, and we hope to work with the Law Students Association for that purpose. But let me turn to your second point, which is a fascinating point. Your question is a very complex one, and it is therefore, unlike Professor Weiler, I don't answer it with one word, no, or not even to say not in my lifetime. My point to you is the answer is yes and no. And it is going to happen in our lifetime. I believe that. Let me explain that. Justice is fundamentally a human thing. Yes, I agree with that. And I think that there will be vast areas of law where we need to feel that a human heart is behind the decision. And to that extent, I don't think, as long as we are human beings, I don't think we will ever displace human involvement in judging. But I think that's not the end of the story, because there are very many areas where artificial intelligence and robots can come in and play a significant role. And that applies both to the preparation and presentation of arguments as well as in the decision making. And let me give you two examples. A few years ago, there was this app created by, he wasn't even a lawyer, I think he was an economics student or something like that, called Do Not Pay. And I think many of you will be familiar with the Do Not Pay app. It was a system designed to help people develop representations to avoid paying traffic fines. And it became so successful that this person is now extending it to a whole lot of other areas. He's gone into law school. He's now studying to be a lawyer, or has become a lawyer. And he's developing this app to replicate that ability to develop arguments in a range of areas. Now, I don't think it'll ever reach a stage where issues of human mercy and criminal justice and big, deep constitutional questions will be dealt with exclusively by a robot. But the fact of the matter is the explosion of knowledge will mean in our lifetimes that to have complete, thorough review and analysis of available information, lawyers will increasingly use robots to inform their submissions to the court. And I believe that in certain simpler cases, that will be the way to go, because you will use the app to get your arguments, put the arguments across at a fraction of the cost. And on the judicial side, I think that there are many levels of minor cases that can be dealt with through artificial intelligence. And if one looks at Amazon, most of you know about the online dispute resolution process that Amazon has. They deal with upwards of 60 million cases using AI and robots. Now, those are small claims. They're very, very small claims, and most people just want an answer, and then it's not worth fighting on, and they want to go ahead. But I'll tell you something. I'm giving a speech at the end of the year on this subject, and it was a stunning statistic to me that their estimate is there are as many as 1 billion legal issues that don't reach a resolution because people can't afford it. Now, those cases, many of them small, many of them routine, I see a role for artificial intelligence and robots to deal with those kinds of cases, at least at a first level. And then if you're not happy, you want to appeal, it goes to a human being. I can see those kinds of models coming on stream. I don't know when, but I can see it. I don't think that it's unrealistic to expect that.
I'm older than you, Chief Justice, so I stick to not in my lifetime. Any other questions from the audience? Yes, sir.
Okay. Indonesia is quite positivistic in
Yes.
their approach, and to what extent the progressive interpretation to the law that actually manifested in the idea of the judge itself for the idea of the development and investment, and to what extent it should be conducted in Indonesia. Thank you.
Okay. I think if I understand your question correctly, what you're saying is that the legal system in Indonesia is quite positivist, and therefore judges stick to interpreting the codes and the legislation laid down by Parliament. And therefore, your question is, to what extent can the courts really play a role in advancing development, right? That's the question. My point actually is not that judges are the vanguard or the leaders of any kind of social or economic revolution. That's not it at all. Judges are the most conservative people in society in general. And I consider myself a very conservative person. What I think the law can do is to give the assurance to people that the rules in the book is going to be administered in the court. The problem with the rule of law is that you can have beautiful rules in the library, but when you come to day-to-day business, if people on the ground don't deal with one another on the basis that the rules in the library is what affects our relationship, then it's just there. It's just a theory. It's pretty, but it has no relevance. That's where judges and lawyers have a tremendous ability to enhance our dealings with one another. So I'm not suggesting that the courts have to take the lead in developing new norms or doing any of these things. But if you have a strong legal profession, a strengthening legal profession, a strengthening system of courts where your rights are enforced according to the law, that, I think, is the way in which you will get investment. Investment will bring development. Development will bring prosperity. That's how I see it. I want to give you that example. I talked about that nation that I visited, and the Minister of Justice was struggling to understand this idea that courts had the final say. And when he asked me the question, why do you do this? And I gave him the example, I told him something else. You know, from the time I landed in that country, the ambassador received me, my ambassador received me. From the time I landed in that country, for the next 3 days, the ambassador was talking to me that one of the biggest problems he had was a Singapore company had made a very large investment 15 years earlier. And the investment got into trouble. The partners had a fallout. For 15 years, they were fighting over it. And they couldn't get a solution because every time a decree or a judgment was given, a phone call would be made and someone higher up would say, no, hold it back. And I said, that's where the rule book is left on the bookshelf. It's not carried into force on the ground. And that's what holds back investment, because you can be sure that company will not invest there. It's not going to invest there because it can't rely on all the assurances that rules exist to provide.
Let's take one last question.
It's heartening that you mentioned about the reforms in legal education. And just before we came over here to the academy, there was a huge legal education summit that was the largest that we've had after more than 56 years. No? And it was led by the Supreme Court. No less than the Chief Justice used it as one of his platforms to look at reform in legal education. It went to the extent of law curriculum, bar examination, law instruction. And so what you mentioned is really very important for us, except that structurally, the Supreme Court lays down the exam coverage, and you now have an existing regulatory body that also somehow provides model curriculum. The problem is, and I give us an example, if an examiner in the bar exam right now in the Philippines will not ask a question about Asean law or any of the agreements, you will not find that in the regular offerings of most of the law schools around the country. And I think that's a basic hurdle that we have to do. If we want to free up, for instance, the curriculum, what is the extent of academic freedom of institutions of higher learning to be able to address concerns, for instance, across jurisdictions now? It's because that's a major hurdle that we have to do. Thank you.
I think there are 2 or 3 points you've made which are extremely valid, Professor. The first is and I want to be clear about this, although I'm the Chief Justice, in this discussion on legal education, I'm just driving the discussion. It is for the deans and the universities to decide at the end of the day whether they go there or not, because of the point of academic freedom that you talked about. I can't mandate, I have no institutional authority to mandate, and I'm not going in a position to mandate and say you have to do this or you have to do that. But I can nag, because of my position of influence, I can nag and ask people, force them to think about things. That's what I'm doing. So I don't have that institutional difficulty that you're talking about. The second point that you make, I completely agree with, which is that I think that we talked about technology or familiarity with technology as a critical issue, multidisciplinary experience as a critical issue in legal education. But I didn't mention the third, which I think is just as important, and that's a much deeper emphasis on comparative law. I think we need a much deeper emphasis on comparative law and an awareness of in our region, ASEAN legal systems. I think that's an essential part of our training, because if people are moving across borders, lawyers need to have some familiarity with what the systems are. And that too is a recommendation that we've made. But that leads me to my third and final point, which is this. Academic freedom is critical, but we run into problems when academics use that freedom to teach what they like to teach and not what is needed to be taught. And that's a fact. I don't mean disrespect to any academics, but there are those who are constantly looking to innovate and explore the bounds of knowledge and thinking. And there are those who are very comfortable where they are and are not interested to go out of their patch. And we have to confront that reality, and deans have a responsibility to figure out how they can address that. Not for me to address that, but I think the deans have to address that.
Thank you. My name's Nukila from Indonesia. Thank you for your sharing your stories to us, your career, your how you to be a Chief of Justice. This general question, because you have achieved as the highest, I think, the position as a Chief Justice. What your next goals in your career, and as a lawyer, as a Chief of Justice, what do you see the most challenge in law in the Singapore? Because I've seen politically and economically, Singapore is advanced in amongst the other ASEAN countries. And what are the challenges of legal enforcement in Southeast Asia region? Thank you.
Thank you very much. Taking the first question first, because that's the easiest. What is my goal? It is to retire safely and peacefully. If I can finish my tenure as Chief Justice without messing things up, I'll be very, very grateful. And that is my ambition.
You did say tenure, not 10 years, right?
No, tenure. Your second question, what do I see as the biggest challenge in my job? I think that the courts play an immense role in preserving order and peace and stability in society, because the pressure that any society faces in terms of order and stability is when the human heart is unhappy. And when the human heart is unhappy, it looks for outlets. And the courts are vital in providing a trustworthy and honest outlet that satisfies most people in order to keep stability. So that, I think, is the biggest challenge, because we are going through a period of frightening change. And on Tuesday next week, I will be giving a major speech, because we're doing the admission of new lawyers, and I'll be presiding at that ceremony. And one of the things that I will be talking about is how dramatic change is today. It's frightening. And that pace of change will cause a lot of tension in society. And we are a very vulnerable society because we're small. We have different racial, religious groups. And to the extent we have been successful, we've been successful because as a nation, there is tremendous trust in our institutions. But you can lose that trust without intending to do anything wrong. And that's my biggest challenge. How to make sure that the court remains that voice for trust, that voice for legitimacy, and that voice for authority. And for the region, I think a different aspect of that, I think change is going to be a very, very frightening and challenging issue that we will have to confront. But I think that for the region, as a lawyer, I think the biggest challenge will be for the whole of ASEAN, all the ASEAN countries, to really embrace this belief that the rule of law is foundational to ASEAN and foundational to our community. And really to make this rules-based commitment a reality, not just a theory. I think if we can achieve that, it'll be wonderful for the whole region.
I've interviewed lots of judges and chief justices, but I've actually never heard somebody make the statement, ultimately it's about satisfying the heart. And I think with these noble words, it's probably the best time to end this part of the day. I want to thank on behalf of all of you, Chief Justice Menon. Thank you very, very much for an enlightening